And now we'll hear the presentation by Katarzyna Katana. The English title is Legal Issues Related to Restitution of Nationalized Real Estate as Demonstrated by the Property Expropriated by the Warsaw Decree. And Katarzyna is going to speak in Polish.
Dziękuję bardzo za udzielenie głosu.
Thank you very much. I have the pleasure to discuss a very complex problem of property in the capital city of Warsaw, which was expropriated by the so-called Bierut decree after the war and is applicable to real estate in the capital city of Warsaw. I do apologize if I do not touch on all aspects of this very complex issue. The Warsaw decree was published on 26th of October 1946 by the erstwhile government. It featured no more than 12 articles, but the key article is number 1, number 5, 7, and 9. Regulations provided under the decree related to real estate located within the administrative boundaries of Warsaw, so the districts of City, Ochota, Wola, Mokotów, part of Targówek Bielany and Ursynów. Our foreign guests probably don't have a clue what these districts stand for, but Warsaw residents are well familiar with those parts of the city. So the decree also related to buildings located within those plots of land, but what was important is that those buildings had to exist when the decree came into force. Okay, so let's get down to details. The lecture will put the spotlight on the question how to differentiate nationalization, communalization, and disappropriation. How is it possible that an act introduced shortly after the war is still in the force, causing so many problems? How can it be deemed constitutional? How was the mechanism of lawlessness instituted, how to prevent effects of the decree, how to finalize all problems it caused, and how to proceed with owners of property who did not have time or did not submit the decree application in time and did not benefit from other prospects provided by other legislative acts. And what should we do with third persons interested in cases filed in line with the act as they wish to acquire the property by different ways? So let's begin with dispossession. After the war, property was never deemed an absolute right. Its limitation was heralded by its definition because the ownership is the right to use an object in a way that it's compliant with social norms and norms of social coexistence. And use of an object contrary to its definition excludes the user from the legal protection. And to manage property according to the civil law is the fastest way to change the ownership. In other words, the ownership can be transferred in line with provisions of the Civil Act. Also, the same code may be used to dispossess the owner of the property. The owner can be expropriated, and expropriation can be performed exclusively by an entity which may apply expropriation by force, offer compensation to the owner, and implement a very complex procedure which involves the right to appeal and finally individual legal act is produced. It's an administrative act. And it's also possible to apply for restitution of the seized property if it's used contrary to its appropriation. Nationalization is deprivation of private property by a general act where you have very visible ideological undertones, whereas communalization is transfer of individual or national property to communal entities. So, first of all, we should examine the historical context for the Bierut Act. Slightly more than a year after the end of the war, it was essential not only because of ideology, but also for social reason, to rebuild the capital city of Warsaw. Probably you don't know, but there were concepts after the war to move the Polish capital elsewhere. So point 1 of the decree defines that the act strives to assure smooth and fast reconstruction of the capital city. It seems to be justified. And it's fair to say that if history was repeated today, probably we should expect adoption of a similar act. The goal of the decree also facilitates its interpretation because the goal of the act was not to dispossess pre-war owners, but probably to facilitate reconstruction of the capital. This is reflected by Article 5, which left the title to ownership to buildings to current owners. And plans for reconstruction of Warsaw echoed pre-war plans of building Western-style inspired modern city. So war damages created an opportunity to build this city again from the scratch, in check with the erstwhile ideology and the line adopted by the then authorities. And architecture was to be the vehicle promoting communist ideas. It was not only the case in Poland. We could see it in ancient Rome as well as pre-war Italy. So let's go back to contents of Article 1 and its provisions. On the day of enforcement of the Act, all real estates located within the administrative borders of the capital city of Warsaw were transferred to the municipality by law. But what was significant was that municipality acquired the legal title to those properties. And this is also when the 6-month period began that enabled the previous owner to appeal from the decision. So this was right which vested in the previous owner the right to administer or manage the property. And if the previous owner did not stood in conflict with the spatial plan, the ownership title was not taken away from the pre-war owner.
Z czasem dokonywano
In time, there were many refusals. Appeals were mostly rejected. So if an application was rejected, the municipality could offer a compensation in form of a plot of land. What did not imply any consequences if, for example, the pre-war owner rejected such offer. And if application was not submitted, or if the right did not get another plot of land, the owner was promised a compensation which was never effected because respective regulations were never adopted. So the ownership of buildings remained temporarily with the owners, but when the negative decision was issued, the ownership title was transferred by law to the municipality, and the former owner could receive for the buildings and other objects he left on the plot, such as rubbles of buildings deemed uninhabitable. So the owner was able to take them away, and if he or she didn't, he was not entitled to any compensation.
Przejdźmy do omówienia.
So let's now discuss how did it happen that the act, which was grounded on sound promises, has led to long-term confusion and problems which have never been solved by city and state authorities. So first of all, for many years, applications were never examined. They were never examined in the 50s, in the 60s. They were finally re-examined after the year 2000, so 60 years after the applications, and commissions which were examining them were making references to other acts than the Bierut Act. Compensation was never granted, compensation taken away from former owners. And proceedings and litigations continue for years, even until today. And today, the legislator has never reacted to the situation, and a Reprivatization Act was never adopted. So those pathologies were publicized by former owners after 1989. Former owners called for annulment of decisions taken in that era. And if a decision was deemed null and void, it was also recognized as non-existent, and very often the case was re-examined, what has opened up the way to receive additional damages for unlawful use of land. Sometimes other decisions were questioned. For example, the decision to sell the property to third persons, and if such property was subject to other people's claims. To sum up,
Zdecydowana
intervention of the legislator in terms of Bierut decree would not only facilitate and help the city ridden by financial problems to solve this riddle, but it could also remedy losses caused by the previous system. It would also strike the right chord with the principle of social justice, which is the cornerstone of a democratic state. So I think that the legislator should offer compensation and also protect people who have procured the property in question in good faith. I think that very soon the European Court of Justice will force Poland to take some initiatives in this area, because right now it is examining several cases filed by pre-war owners of real estate in Warsaw. Until that time, cases should be individually examined. Unfortunately, those litigations take a lot of time, and decisions should be taken and rulings should be awarded after swift proceeding, and they should be aligned with current interpretation of the law. Thank you very much.